This is lecture number 2. It's the Supreme Court. Now, as you know, Supreme Court was written about in the Constitution in Article 3. It is the only court mentioned in Article 3, and it's the only court that existed when the nation came into existence back in 1789. But the Congress quickly remedied that by passing the Judiciary Act of 1789, establishing the circuit courts and the district courts. Now, the Supreme Court consists of 8 associate justices and 1 chief justice. The number of justices is set by Congress. Now, if you remember from your U.S. history, that Roosevelt tried to change that from 9 to 15, and ultimately it was a political defeat for Roosevelt. It was 9 then, it's 9 now, so obviously he didn't get his way. Now, at points in U.S. history, there's actually been as few as 7 justices, as presidents have perhaps not decided to name new justices to the court. But in the 20th century, it's been a stable, at the end of the 21st century, it's been a stable number at 9. Now, when the position of Chief Justice is vacant, as it was in 2005 when Rehnquist died, the president can appoint somebody already on the court, or the president can appoint someone new to the court. Now, that's happened both ways. In fact, Rehnquist, who was replaced in 2005 because of his death by John Roberts, replaced the Chief Justice back in the 1980s when Reagan was president. Rehnquist was already an associate justice. Reagan moved him over to the Chief Justice spot, and at the same time nominated, or within that time, nominated Antonin Scalia to the court. Now, Scalia comes after the fight over Bork. Another example of anybody who has not been on the court but at the same time has been nominated by presidents, Earl Warren, John Roberts, Sotomayor. And that's the normal way that people get on the court. Usually the Chief Justice is a person who comes from the outside. Now, the background, of course, with the court, you have the understanding that it is the highest court in the land, which also means it's the court of last resort. You lose here, you lose. And there's maybe 1 or 2 ways around that, and we'll discuss a couple of those avenues at the end of this lecture. Now, the key power that the Supreme Court has is, of course, judicial review. Now, judicial review comes about in 1803. It's a case that's initiated after the 1800 election when Marbury was refused a seat on the bench by Thomas Jefferson, who refused to seat Adams's midnight judges. So Marbury sued. The Madison, of course, in this case, is the Attorney General, James Madison, who becomes president later on. But in this case, the ability of the court to review legislation was what was established under judicial review. And as a matter of fact, the court said that under the Judiciary Act of 1789, they didn't have the right to order Thomas Jefferson to seat Marbury. And by just reviewing the case from that perspective, they established the ability of the courts to look at laws, and of course that is the power of judicial review. Now, 224 state laws have been declared unconstitutional. That was as of 2002. There's probably been a couple since then. 158 federal laws have been declared unconstitutional. That's also since 2002. And some presidential actions have been declared unconstitutional. U.S. v. Nixon in 1974 refined the way the court looked at executive privilege, and on occasion a presidential order has been countermanded by the courts, um, but it doesn't happen very often. Now, why is the power of judicial review needed? Well, the power helps both Congress in finding a pathway to find what is constitutional, and at the same time, the Constitution itself is also broadly worded. The Second Amendment, for instance, which wasn't, at least in this age, finally interpreted by the court until 2010. And secondly, the power of judicial review helps the courts sometimes overturn precedent. So, for instance, if precedent was set in cement, and it quite often is, we would never, ever as a country have overturned separate but equal, the Plessy v. Ferguson case of 1896. But the court does retain the prerogative to change its minds, its collective mind, especially over time and after a society changes and what seemed okay and acceptable to a majority of the population in 1896 is no longer acceptable in 1953. And the court does recognize that sometimes they have to change with the times. Now, there's two types of jurisdiction that the Supreme Court deals with. One is original, the other one is appellate. In original jurisdiction, these kind of cases involve the states or involves an ambassador, though that has changed now that the Washington, D.C. courts have concurrent jurisdiction. Those cases go through that venue. The Supreme Court, though, would conduct the trial. And then there is what's known as appellate. And with the appellate type of case, these are the more numerous types of cases the Supreme Court takes on. They come from the courts of appeal, otherwise known as the circuit courts. They come from the state Supreme Courts. An example would be Prop 8 from California, which has been declared unconstitutional by the California State Supreme Court and is now on its way to the Supreme Court. I believe they have said that they will take it on this term. So the cases from appellate jurisdiction are far more numerous than cases from original jurisdiction. So how does a case reach the Supreme Court? Well, remember, the court cannot reach out and grab a case. They have to wait for the case to come to them. And thousands of requests are made for the Supreme Court to review cases each year, but relatively few of those requests are granted. In fact, the recent trend has went from approximately 90 cases a year down to 50 to 60 cases a year. As the cases have become more complex, the court says it needs more time and needs to expend more energy in making sure that they make the right decisions. And because many of the cases are technical, they have to do research. The clerks have to do research. The justices themselves need to make sure that they understand the technical aspects of the case. And it seemed to them, I guess, as they were at 90 cases a year, that it seemed as if they were rushed to make decisions. And so they want to only accept the most important decisions, or the most important cases that will come to them so they can make a decision. Now, surprisingly enough, it does not take a majority of justices to decide to take a case. But it takes I guess we call this a super minority in order to do so. It takes 4 of the 9 justices to bring a case to the court. Now, this is what we call the rule of 4. In order for the court to decide a case, 4 justices must agree to do so. Denying a decision may mean any number of things. First and foremost, a case may lack a substantial federal issue, and therefore whatever's been decided at the district or the circuit court level or even the state Supreme Court level will suffice. A party may lack standing. We've talked a little bit about the Newdow case, in which a man sued on behalf of his daughter because he didn't want her saying the Pledge of Allegiance. but the Supreme Court decided that he lacked standing because he and his wife had divorced and she had custody. So therefore, he's found another couple of families which he's now representing as their attorney, and that will probably track its way back to the courts again. On many occasions, the court itself agrees with the lower court. There's no reason to review the case. From their perspective, the lower court made the right decision. And then there's the political hot potato. It's a kind of case that may be the tip of the iceberg for a number of cases, and the court decides at this point in time they don't want to take on the case. It's something they just don't want to touch. Gay marriage has been like that. Abortion has been like that. So the rule of 4, big concept, one you need to know and remember. Now, when a party requests a Supreme Court decision, it files a petition for a writ of certiorari, or what's known as, in the short term, or in the short form, a writ of cert. And in Latin, this is defined as to be made certain. These petitions are screened by the court's law clerks, and then they're reviewed by the justices on the rule of 4 basis noted above. Now, when the justices accept a case, they can decide whether to ask for more information and hold oral arguments from the attorneys, or they can decide to take on the case, look at it quickly, and make a decision based on the attorney's briefs. Now, cases decided without further information are announced with what's known as a per curiam opinion. This is a very brief, unsigned statement of the court's decision. This actually happened this week when the court, on a 9-0 vote, determined that dogs who are trained to sniff out drugs can be used in almost every instance. I'm not quite sure of all the ramifications or all the facts about the case, but it pretty much was a 9-0 case, and the court was unanimously behind the decision. Now, when the Supreme Court looks at a case, they kind of follow the same pathway. Now, their year begins on the first Monday in October and continues till the end of June, unless there's a special case that they need to take on. Now, they did that in 2002. They started actually at the very beginning of September, and it took on one case in particular, or one case in specifically, and that was the McCain-Feingold Campaign Finance Act. And the court found, after holding oral arguments and then coming up quickly with a decision, that most of the elements of McCain-Feingold were constitutional. Now, the court will hear cases from Monday through Thursday, and they need 6 jurors on the panel. They need 6 of the justices to be present in order to have a quorum. Now, before the oral arguments are held between the attorneys representing the plaintiff and the defendant, the justices read the attorney's briefs, and they will also read and perhaps discuss among themselves, or at least discuss with their law clerks, the amicus curiae briefs, or what's known as the friend of the court briefs. Amicus is A-M-I-C-U-S, curiae is C-U-R-I-A-E. It's one of the vocabulary words in your packet. And the justices, it's hoped that the justices take something from these amicus curiae briefs, because they're filed on behalf of both sides, and they try to illuminate for the judges just how important it is the judges either keep a law in effect or overturn it. And so they're designed to give the justices a broader sense of what it is about the case that these people feel are important. Now, the justices will hear 30 minutes of oral arguments from both the plaintiff and the defendant's attorney. The justices, though, uh, sometimes in rapid fire sequences, will shoot questions at the attorneys. And if you're not fast on your feet, you look, or you can be made to look rather inept, even if you're not. Most attorneys, most great attorneys, at some point in their life, may get to argue a case before the Supreme Court. It's an amazing thing. People say, who have been in the position, say it's some of the most terrifying 30 minutes they'll ever spend in their life. It can be exhilarating. You make the most of it. But the justices, 9 learned men and women, will have a number of questions. They'll drag you this way and that way. I would love to be at an oral argument session of the court, hopefully one of these days. Now, on Friday, the justices get together in the conference room. They close the doors. The meeting is led by, of course, the Chief Justice, and the Chief Justice will vote first on the cases before them, and explain why they are voting that way, and then they will go down the pecking order, and the last one to vote is the last person to enter the court. That person is also assigned the task of taking the notes, and they will have that task until a new justice arrives, except if it's the Chief Justice. A new justice arrives, and then they get the secretarial duties in conference. Now, they discuss the cases, they vote. A simple majority is needed for the decisions. In the case of a tie, the previous court decision stands. So if the case was appealed from the circuit court or the Court of Appeals, then that court's decision will remain in effect. Now, after voting on Fridays, it doesn't mean that they walk out Friday afternoon and announce how the justices voted. They have to write the opinions, and this is where the Chief Justice is able to exercise one of their greater powers. Now, if there's a unanimous decision, that means that all 9 justices felt that this was the way the case should be decided. About 1/3 of all cases that reach the Supreme Court are decided by a 9-0 vote. But when there isn't a 9-0 vote, it's 5-4, 6-3, 7-2, 8-1, that means that the court has to produce a majority and a dissenting opinion. The majority opinion expresses the opinion of the majority. A dissenting opinion expresses the opinion of the minority. And the dissenting opinion is important because if the court later on changes its mind, it overturns precedent, it may draw upon the minority opinion for its reasoning. Now, there's one other type of opinion that goes with this, and it's called concurring. A concurring opinion is written by a justice who agrees with the majority's conclusions, but for very different reasons. Antonin Scalia and Justice Thomas are ones who write quite a few, especially Thomas writes quite a few concurring opinions, coming to the same conclusion as the majority, but for very different reasons. Now, this is where the politics comes in. Who gets to write the opinion? Well, first and foremost, if the Chief Justice voted with the majority, he assigns someone in the majority to write the opinion. It could even be himself, and John Roberts has. John Roberts assigned himself the Obamacare opinion in 2011, or 2012, excuse me. If the Chief Justice is in the minority, the most senior justice among the majority assigns the opinion. And that's fair. So for the Chief Justice, this is one of his most important powers, assigning the opinion, because you've got 9 brilliant minds at work here. Many of them would like to write the opinion, but they can't have all of them. And so consequently the Chief Justice has to kind of spread the wealth, or at least usually that would be the case. So assigning the opinion is the key power of the Chief Justice. It enables the Chief Justice to get the right slant on the issue. But here's what's interesting. The majority opinion writer must be so careful as to not alienate others in the majority, because they may change their minds and switch positions. That has happened. So usually the writer of the majority opinion does circulate when it's very important cases. Usually will circulate among those who voted the same way a draft copy of it, so that the writer can get some feedback, and to make sure that he's not losing, or she's not losing, the others who voted the same way in conference. The majority opinion writer must therefore structure the argument in such a way as to keep the support of at least 4 other intelligent, independent justices, any of whom may threaten to jump ship and switch his or her vote. And you may not want, as the majority opinion writer, also a concurring opinion which calls into doubt your reasoning. So you want to kind of create sometimes a big tent. Now, the threat of a dissenting opinion can sometimes convince the majority to bend a bit in certain parts of the decision. That's where, in the current court, perhaps Anthony Kennedy comes into play. You want Kennedy, he's the deciding vote. You've got 4 conservatives and 4 liberals. You don't want to be inflammatory if you want Kennedy to perhaps come back and side with you instead of perhaps the way he voted the first time. So what are the purposes of the opinions? Well, they communicate the court's reasoning as to why they came to the conclusion that a law either stood or fell. And so it's important that the public understand the legal and constitutional reasoning behind their decision. Now, every decision made by the court also sets precedent for future cases. This is now the new benchmark in which all future cases have to be decided. And that's the importance of stare decisis. Let the decision stand. The court can also drop hints that Congress, the states, the president take certain actions. Robert basically said this in his Obamacare opinion. It wasn't up to the court to fix the mistakes made by Congress. And he was right. As disappointed as I was in the decision, he was right. The court refused in this case to make a political decision. I still think they should have voted the other way, but they didn't. The court doesn't usually struggle with the problem of people not obeying their decisions, at least blatantly. Now, we do know that Nixon in the late 1960s, after he became president into the 1970s, drug his feet on enforcing desegregation orders that came from different federal courts. So we know that the Supreme Court, despite being the highest court in the land, isn't infallible. People will attempt to evade the court decisions. Now, the best way and the most permanent way to do that is to amend the Constitution. The court can't strike down something as unconstitutional if it is in the Constitution. The closest political decision that has come to being a factor in amending the Constitution was the attempt by Congress to pass an anti-flag burning amendment. I think it passed the House 3 times. It failed the Senate all 3 times, but just by 1 or 2 votes. Since then, burning the flag doesn't happen all that often. It usually happens outside the country, not inside the country, so it's not as much of an issue now as it was back then. Now, when a decision is made, it can be remanded, and it normally is remanded to the lower courts to carry out the Supreme Court's decision. But that lower court has a little bit of leeway in doing this. And they can also do it rather slowly, or perhaps not as fully as the court intended when it gave the decision back to the lower courts to carry out. A third way is that the executive branch says, hey, we're just not going to follow your order. That's what happened in 1829 when Jackson ordered the removal of the Cherokees. And the Supreme Court said you can't, and Jackson's famous line, John Marshall has made his decision, now let him carry it out, made Marshall seem like an empty paper bag, because Marshall had no one, and the Supreme Court has no army to carry out its decisions. They have to rely on the federal government to do so. In 1957, Eisenhower had a political dilemma when he had to decide whether to send the National Guard into Little Rock in order to guard the Little Rock Nine as they integrated Central High School. And he made the right decision by sending the National Guard and the 182nd Airborne in. I'm sure some people said they would never vote for him again, but he had the kind of prestige to do what was morally and ethically right. The states and local governments may also drag their heels. Actually, some of them may refuse to actually carry out a court order, things like desegregation, school prayer. The schools or the local governments will actively try to find some wiggle room. It does happen. And, when we look at this too, the Constitution may be what the Supreme Court says it is, but a Supreme Court opinion is what a trial judge or a policeman or a school board or a city council says it is. It's kind of interesting from that perspective. Now let's see who's on the current court. Well, the liberal voting bloc is Ruth Bader Ginsburg. She was nominated by Clinton in 1993. Stephen Breyer came in the same year. Sonia Sotomayor came in with Obama in 2009. Elena Kagan in 2010. And that's the 4 liberals on the court. The 4 conservatives on the court: Antonin Scalia, nominated by Reagan in 1986. Clarence Thomas came on board in 1991. John Roberts in 2005. Samuel Alito in 2006. And the swing vote is Anthony Kennedy, who came onto the court in 1987. He's a swing moderate conservative, usually swings to the right, but on occasion will vote with a liberal bloc. Let's take a look at their pictures. Let's get some names to faces. So in the middle is John Roberts. He is the Chief Justice of the Supreme Court, probably young enough to be there for the next 20 to 25 to 30 years. And to his right is, at the top, Clarence Thomas. And to Clarence Thomas's right, Antonin Scalia. And as you go below Antonin Scalia is Samuel Alito. And then to Samuel Alito's left is Anthony Kennedy. Now on John Roberts' left is Ruth Bader Ginsburg at the top. And to her left is Stephen Breyer. And below Stephen Breyer is Sonia Sotomayor. And to the right of Sonia Sotomayor is Elena Kagan. So that's the current court in picks. And when we come back next time, we'll start talking about judicial activism versus judicial restraint. So until then, have a nice evening.